Hey friends, Casey Ashmore coming to you from the studio. Thank you so much for joining us. Today we're going to be talking about outcry statements that come up in both family law and criminal law situations where a child has made a statement or a parent has overheard a statement or a parent observes what they believe to be some sort of abuse to the child. So a statement is made to a law enforcement agency, and that triggers the following things. Typically, it triggers a CPS investigation, Child Protective Services. CPS will work with local law enforcement to meet with the parent who observed the abuse or reported the outcry. The child usually then goes to a CAC, a Children's Advocacy Center, where they are forensically interviewed. They're put in a calming, non-stressful situation, environment, and they are not coached or prompted, and it is an opportunity for investigators to see if the child will repeat the outcry statement without prompting, without coaching. Sometimes that happens, sometimes it doesn't. Doesn't mean if there's no affirmation at the CAC, doesn't mean the case is over. Next steps will occur, and typically that is continued investigation with CPS, sometimes a parent safety meeting. Parent safety meetings can occur, and if you've got blended families like a lot of families are, there can be a parenting plan that is agreed upon by CPS and the other parents that says, well, whatever's going on here with this parent, until that's resolved, no contact or what have you. We're going to put the child with grandma until these things are resolved. But the other things that happen is that the parent who's the alleged abuser is now the target of a criminal and sometimes civil lawsuit, right? There's going to be a law enforcement investigation and perhaps a grand jury presentment, and then there's possibly going to be a family law case, whether that is brought by the district attorney's office in the form of a protective order under the Texas Family Code for family violence, which is how we define abuse, or it's in conjunction with the other parent bringing a family law protective order and temporary restraining order against the alleged abuser, or all of the scenarios that I just talked about. A criminal investigation, the district attorney's office presenting a family law protective order, they're the only ones who can do that, and then a protective order brought by a civil parent in a civil lawsuit seeking, again, protections. Now, how do you deal with all these? You got a lot coming at you, right? And there's ways to deal with that, and it's a hard one to do because to deal with it effectively, and in fact, one of the maybe the only way, maybe it's a way you can't deal with, but if you don't participate in the investigation, if you're the target of that investigation and you're refusing to participate in that investigation, if you're invoking your constitutional right to silence, which you have every right to do, law enforcement is going to narrow the target directly to whoever's invoking that right to silence. And they're going to wonder what they've got to hide. And then there's the flip side of that, is waiving that constitutional valuable right to silence and participating in that investigation, knowing that the government and perhaps your other spouse, the other parent might be bringing the full weight of both their financial resources and the government's unlimited resources to bear on you, the sole target of that criminal investigation. So waiving that right is a big thing. I'm going to get into that more in the next video segment. Thank you so much for watching. Please like, subscribe, and share. Leave me a question or comment, and I'll do more on this video series on outcries and voluntary statements next. Thanks so much again for joining.